Hello and welcome to another episode of Supreme Court Judgments of the Week on Verdictum. In this segment, we bring to you the most interesting judgments passed by the Supreme Court during the previous week. Let's begin. Priia Andoria versus State of Karnataka and others. In a landmark ruling, the Supreme Court empowered high courts and session courts to issue transit anticipatory bail for offences committed beyond their territorial jurisdiction. This decision stems from a case involving a complainant wife who sought justice after facing alleged death threats, dowry harassment, and cruelty at her marital home in Rajasthan. The accused, including her husband and family members, applied for anticipatory bail under Section 438 of the Code of Criminal Procedure 1973 in Bangalore, despite the FIR being lodged in a different state. The Sessions Judge Bangalore granted the bail, prompting the wife to appeal before the Apex Court. There were two major issues before the Apex Court for consideration: whether the power of the High Court or the Court of Session to grant anticipatory bail under Section 438 of the CRPC could be exercised with respect to an FIR registered outside the territorial jurisdiction of the said court. Another question was whether the practice of granting transit anticipatory bail or interim protection to enable an applicant seeking anticipatory bail to make an application under Section 438 of the CRPC before a court of competent jurisdiction is consistent with the administration of criminal justice. The Apex Court dismissed the appeal, asserting crucial considerations. A bench of Justice B.V. Nagaratna and Justice Ujjal Bhuyan observed that anticipatory bail as well as transit anticipatory bail are intrinsically linked to the personal liberty under Article 21 of the Constitution of India. In its verdict, the top court highlighted the importance of access to justice, particularly for individuals residing in a different state from where the offence occurred. The court acknowledged the necessity for accused persons present or residing in a third state for legitimate reasons to seek limited anticipatory bail of a transitory nature. Consequently, the court sanctioned high courts and sessions courts to grant transit anticipatory bail for offences committed outside their territorial jurisdiction, subject to specific conditions such as giving notice to the investigating officer and public prosecutor before the order for limited anticipatory bail is passed, recording reasons as to why the applicant apprehends an interstate arrest and the impact of granting such limited anticipatory bail on the status of the investigation. The applicant of the anticipatory bail must satisfy the court regarding his inability to seek the bail from the territorial jurisdiction of the court that has taken cognizance of the offence, among others. P. Kishore Kumar versus Vittal K. Patkar. In a significant ruling, the Supreme Court reiterated that revenue records are not documents of title. They neither create nor extinguish the title of ownership. A bench of Justice Bela M. Trivedi and Justice Dipankar Datta noted. This case centers around a legal dispute in Bangalore, where the plaintiffs staked the claim to ownership based on family settlement dating back to 1953. This was opposed by the defendant asserting superior title granted to him by virtue of the Mysore Personal and Miscellaneous Inam Abolition Act of 1954. A pivotal element of the dispute was the Commissioner's order, which granted occupancy rights to the vendor of the plaintiff. Initially, the trial court passed an order in favor of the plaintiff based on the Commissioner's order. The appellate court, however, overturned the decision and upheld the Inam Abolition Act. But the High Court upheld that the plaintiff had a better title. Now the matter reached the Supreme Court, which criticized the High Court's decision, stating that it erred in reversing factual findings by the first appellate court. The court highlighted the failure to harmoniously interpret the order passed by the Commissioner and the Act, deeming the decision indefensible. Placing reliance on the case of Nazir Muhammad versus J. Kamala, the top court clarified that second appeals stipulated under Section 100 of the Code of Criminal Procedure 1908 required a substantial question of law affecting the rights of the parties. Dismissing the argument that revenue records confer occupancy rights, the top court rejected the claim for occupancy rights as a tenant by the vendor of the plaintiff. The court then reiterated that mutation in revenue records does not alter title and hold no presumptive value. Highlighting the deficiencies in the case of the plaintiff, the court emphasized that the sale deed did not trace the title to a government grant, but through a sale deed. The court consequently dismissed the plaintiff's suit, stating that he failed to prove the case to a high degree of probability. The top court allowed the appeal and overturned the impugned judgment and decree. Bajaj Allianz General Insurance Company Limited versus Mukul Agarwal and others. A bench of Justice Abhay S. Oka and Justice Rajesh Bindal presided over the present case and made an interesting observation that the insured has no right to claim car replacement when the insurance policy does not have any such provision. The case involves an insurance dispute between BMW India, Bajaj General Insurance, and a car owner named Mukul Agarwal concerning the replacement of a damaged BMW 3 Series 320D car. The dispute originated with Mukul Agarwal filing an insurance claim with Bajaj General Insurance, which was denied, citing factors such as delay in claim submission, non-response to insurer correspondence, discrepancies in accident descriptions, and the discovery of blood stains inside the vehicle. Agarwal sought recourse through the State Consumer Disputes Redressal Commission, which ruled in his favour, directing BMW as well as Bajaj to indemnify him for the replacement of the car. The order was also upheld by the National Consumer Disputes Redressal Commission, which prompted BMW India and Bajaj to appeal against it before the apex court. The Supreme Court observed that the insured was entitled to monetary compensation from both the BMW and the insurer. However, the direction of the SDRC and NDRC to replace the car was not sustained. The court noted that the insured does not possess an automatic right to claim car replacement if the insurance policy lacks explicit provisions in this regard. But the insurance company's denial of claim based on delay in reporting the accident was deemed invalid by the top court. With that, I am Anya Singh. Thank you for watching Verdictum. For more such informative content, don't forget to subscribe to our channel and download the Verdictum app on iOS and Android for latest legal updates.